Good morning. Good morning, everybody. My name is Judge Kim Teresa Malika. You're here in First Appearance Magistrate Court. Today, you're going to be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. You also have a right to an attorney. We have Mr. Romero, who I believe is at the main jail, and we have Ms. Mariti to my right from the Public Defender's Office. We have Assistant State Attorney Eric Linder from the State Attorney's Office, and we have Shawana Jerkins as our clerk. All right, ready to proceed, Mr. Linder?
Yes, ma'am.
Okay. All right, we're going to call a case out of turn. It's Jose Perez. I don't know what page it is. I'm sorry. I just pulled it out of the packet.
Oh, here.
The reason why Page 11, thank you, Mr. Reedy.
I don't think it's
The
yours.
reason why I called it, I don't know if, is he here, Mr. Perez?
He's North Broward, Judge.
North Broward. He was supposed to be brought to Judge Poll this morning. Because we found, remember he was a medical reset, and he had the two 250 bonds, and we decided since it was a battery and a criminal mischief.
I do remember.
Is he there?
He's refused. Yeah, he's refused.
He was supposed to go to Judge Poll. Because we found probable cause yesterday, and he refused, or he didn't appear. Yesterday, he was a medical reset. So I don't know if someone wants to get in touch with Judge Poll's division, or let me call Judge Poll's office. I'll be right back.
You said you found that public cause yesterday?
Yes.
They didn't give a findings sheet yesterday.
It's still here. Okay. So what color? Yellow? All right, so this top one, actually, Madam Clerk, you could just discard that. And then you can give it back, and I'll give confinement to yellow. There you go.
Judge, considering this is from yesterday, can you still just check and sign it, and I'll make a note on the finding and orders?
Well, there's one,
Already here, okay.
yeah, I'm gonna put delete, PC found,
Oh, so that's the one from
112918.
Okay,
Yeah, they shouldn't have brought it here today.
okay. Thank you.
You're welcome. Okay, Brandon Williams, please. We're just deleting him from our docket. Thank you. Brandon Williams,
Brandon Williams is here at Maine.
main jail, thank you. Good morning, Mr. Romero.
Good morning, Judge.
All right, so Mr. Williams, good morning. You have an out-of-state hold out of Georgia, theft by the taking, fleeing or attempting to elude police, reckless driving, and aggravated assault. You have a no bond hold, so we'll see you in extradition court, sir, Tuesday or Thursday at 1 p.m. The court does find probable cause, and you'll be held no bond until then. Thank you.
Except maybe the family might be here.
And Detective Cruz, we'll take yours right after I do the, we have to do these first. Okay, Ralston Payton, please.
He's here at me.
All right, Mr. Payton, you also have an out-of-state hold for a felony out of the state of Maryland for probation violation, robbery. You're gonna be held no bonds, court finds probable cause. We'll see you in extradition court, sir, Tuesdays or Thursdays at 1 p.m. Thank you. All right, and then we have, is it Mavis Johnson?
Yes, ma'am.
Okay, let's call up, we have a detective here. Hello, good morning. Can you announce your appearance for the record, please?
Detective Christina Cruz, Pembroke Pines PD.
Okay,
Good morning, Your Honor. Richard Sherman from the Office of Statewide Prosecution.
Hi.
Hi, how are you doing?
good. All right, so you're gonna be handling this case today, or?
Mr. Lender's going to handle this case, but if Your Honor may hear from me on a different.
Absolutely.
Okay.
Okay. All right, so, Ms. Johnson, you have larceny. $300 less than $10,000 from a 65 years of age or older, $10,000 bond, fraud, misrepresent, self-commit, personal ID, $5,000 bond. 3 is illegal use of a credit card more than 2 times in 6 months. For goods, $100+ $5,000 bond. Count 4 is larceny. This writing is so small. Is it 500? Larceny. Count 4 is larceny between $300 and $10,000 from a person 65 years of age or older. So that's the same as count 1. $10,000 bond. 5 is fraud, misrepresent, self-commit, personal ID. $5,000 bond. And count 6 is illegal use of a credit card more than 2 times in 6 months, goods $100+ $5,000 bond. Count 7 is petty theft, second degree, third subsequent offense, $1,000 bond. The court does find probable cause. I believe this was signed by, Judge Dennis Bailey.
Yes, ma'am.
Just make sure there's no second page. Okay, what say you, State?
Thank you, Your Honor. And just to advise the court, Mr. Sherman's here because while this case is assigned to the state attorney's office right now, I believe my office is going to be working with Mr. Sherman's office going forward on this matter. So,
Okay, thank you.
Your Honor, the state is going to be requesting that Your Honor keep the bonds that Judge Bailey set in place.
Okay.
We're also going to be requesting a GPS monitor. Your Honor, we're going to be requesting no victim contact, no return to any of the locations listed as part of this case.
Okay, so let's just go through those first.
Sure.
One is Home Goods, which is located at 11251 Pines Boulevard. I'm assuming that's in Pembroke Pines at the Sawgrass?
Pembroke Pines and, Lake Hiatus.
Okay, all right, so that's one, and then the next one is Sedano's, which is located at 10333 Pines Boulevard in Pembroke Pines as well. And then we have Sedano's is the next one. And then we have TJ Maxx and Marshall's. Well, she's the subject of an investigation there. Okay? And what's the name of the alleged victim? Because it says victim Novo, victim Scott. It doesn't have anything else. Do we have the initials of all the victims?
3 separate victims.
Okay, just give me their initials.
If I could have a moment, Your Honor, I can get that for you.
For Scott, it's Kay Scott. She's actually, doesn't reside in Florida.
Okay, but
Karen
I'd still,
Scott.
just in case they come down.
Novo, I want to say it's El Reyes. I'm not sure the first initial for Novo. It would be actually in my
Yeah, I've got access to that, so. DN.
Okay, so there's no return to the home goods, no return to Sedano's, no victim contact, direct or indirect, with KS and DN,
And there's one more, Your Honor.
okay?
Reyes.
Yeah. That was the 817.
I think that would be AR.
Okay, so no return to home goods or Sedano's, no victim contact, ma'am, direct or indirect, with KS, DN, or AR, and if you go back to any of those locations, you'll be arrested or have any contact, direct or indirect, with the alleged victims. All right, what say you, state anything further?
Yes, Your Honor, the state has a great concern, not only based on the allegations in this case where it appears that Ms. Johnson, it's the same MO in all these instances. She's targeting elderly victims for various reasons. But also, Your Honor, Ms. Johnson has a lengthy criminal history for just this type of criminal activity. Her history includes, one moment, just out of Broward, 2013, theft and unlawful use of false name identity. 2011, criminal use of personal identification information and theft. She violated her probation, was sentenced to just over 19 months in Florida State Prison.
When was that, 2013?
That was 2011. She was
11.
she was sentenced in 2013.
Okay,
2011, grand theft. Again, violated her probation, was sentenced to the same sentence, just over 19 months to run concurrent. 2008, felony theft due to 2 or more priors and battery, 18 months state prison. 2008, grand theft, felony credit card fraud, again sentenced to 18 months concurrent. 05, grand theft, criminal use of personal identification information, 3-year state prison. Theft, 02. 2000, forgery, felony credit card fraud. 2000, grand theft, forgery, felony credit card fraud and theft. 98, grand theft. 97, grand theft with a violation of probation. Additionally, out of Palm Beach County, in 2013, she was convicted of grand theft, sentenced to 1 year and a day state prison. In 2008, convicted of grand theft against a victim over the age of 65 and fraudulent use of personal identification information, sentenced to 18 months state prison. Her most recent release from state prison was June 21st of 2016, and I am showing 16 prior arrests for failures to appear in court, a total of 34 prior felony convictions, and 22 prior misdemeanor convictions. And, Your Honor, I would defer to this point to Mr. Sherman, Detective Cruz, if they have any additional information they want to provide.
Morning again, Your Honor. So I'm with the Office of Attorney General, Division of Statewide Prosecution. I'm an Assistant Statewide Prosecutor. We have an additional.
Welcome to Magistrate Court, by the way.
Thank you very much. We have an additional 10 to 20 cases that we have been awaiting just a witness statement for in-court identification, where we have the surveillance, where it appears to be that law enforcement identified this individual, but we had been, we're in the process of wrapping those cases up. So I wanted to, even though I don't have standing, I do want this to ask this court to consider if she is released, that you do do a GPS ankle monitor.
Thank you. All right, what say you, defense?
Judge, at this time, I ask you not to take that into consideration as far as things that may happen or charges that may come down the pike. If they do come down the pike, she will be appearing in magistrate court and she'll be given the appropriate magistrate hearing for those offenses. Judge, I'd ask you just to take into consideration what Mr. Lunder says at this point. And speaking with Ms. Johnson, she's 52 years old, been living in Florida her whole life. At this time, she's advised me that she's not working. The last time she was working is basically cleaning houses, where she made approximately $300 per week.
When was that?
Her and her daughter. From what she advised me, 2011. 2011, Judge.
Okay, go ahead.
Thank you, Judge. She lives in Delray Beach with her daughter and her grandchildren. She has 6 grandkids that live with them in Delray Beach. Her granddaughter right now collects disability, and she receives child support payments from the 6 children. So I believe the total the total monthly rent is approximately $1,100 per month. They do not own, they rent, and they've been renting there for about 2 years. From what she advised me, she owns no property. Her daughter does, however. She owns a 1995 Durango. That's my understanding as far as what the family assets are. Right now, Judge, she's not in any position to put or place the monetary bond, which is currently said, if my math is correct, is $41,000. I'm going to be asking for a bond reduction. On count 1, the first count is $10,000. I'd ask the court to consider reducing it from $10,000 to $2,000. On count 2, I'd ask for a bond reduction of $1,000. I'd ask for a bond reduction on count 3 of $1,000. On count 4, I'd ask for a bond reduction from $10,000 to $2,000. On count 5, I'd ask for a bond reduction from $5,000 to $1,000. And on count 6, a bond reduction from $5,000 to $1,000. On the felony petty theft, I ask the court to consider an ROR. If my math is correct now, I'm asking the court for a total of $8,000. I do understand as far as Ms. Johnson's lengthy history, so at this time I wouldn't have any sort of objection. She's helped take care of her grandkids. I wouldn't oppose to a level 2 with GPS. So I believe level 2 with GPS, where she'll be constantly supervised, will know her whereabouts, and with an $8,000 monetary bond, I believe at this point that is reasonable from the defense's position, Judge.
I also have some questions. Maybe I could just, for clarification purposes, I was handed the affidavit just before court started.
Want
and I've
time
been
to read it?
reviewing it so far. No, I think I just maybe can have this cleared up. Maybe the state can clear this up. Count 1, 2, and 3 on the docket. Who is the victim in those 3 counts?
What is it? 1?
1, 2, and 3.
Thank you.
Or even the date of those offenses would be
Is this for
fine.
probable cause purposes or clarification?
Yes, no, it's for probable cause
Well,
argument.
probable cause is found by Judge Bailey.
Yes, well, Judge Bailey may have made a mistake, and certainly Judge Malika can review that. So I would ask again, who is the alleged victim, or what is the date of the crimes charged in counts 1, 2, and 3?
All right, if you want time, we can recall it. You can read it and make your objection.
I've read it, and I don't see it in here. I don't see a correlation between what is listed as count 1, 2, and 3 as to how it relates to which charges those might be. So I want to know who the victim is in count 1, 2, and 3.
Well, considering that the warrant lists the dates that they occurred, maybe Mr. Reedy, you'd want to correlate the dates with the allegations.
Okay, and then count 1, 2, and
All right,
3
this
would
is
be
what we're gonna
the
do.
incident of August
We're gonna
12th.
pass this, read the probable cause.
I've read it.
Okay, I'm finding probable cause based on Judge Bailey, so if you wanna make an argument, that's fine.
Okay,
I
I don't
just
see
don't wanna-
anything in here that indicates that the
Mr.
victim in
Reedy, let me
count.
finish. I don't wanna get
Yes.
into a question and answer. If you have a certain objection, you can certainly make it. I don't have a problem with that.
I don't see anything in this warrant that indicates the age of the victim in counts 1, 2, and 3 to qualify this as larceny from a person 65 years of age or older.
Okay?
List their ages in the warrant.
That, I would argue that's insufficient, unless there's, what's her date of birth? Why don't we have that information? Why isn't her age listed in the actual body of the affidavit? This is an incident, I'm assuming counts 1, 2, and 3 are based on the August 12th incident at Home Depot, where the victim is last initial is a N. I don't see anything in here about her age. The only thing I see is a conclusory statement in the warrant stating that she's 70 years of age. Is she exactly 70 years of age? Is she older than 70? Is she a little younger than 70? And how do we know that? Without something more contained in this warrant, I would argue that the element of the crime that makes this a larceny from a person 65 years of age or older is missing.
It's not conclusory. It would be conclusory if it just stated the victim was over the age of 65. It gives an exact age.
Okay, what say you, Mr. Romero? Anything further?
Judge, not at this point.
I would like to know who the victim is in counts 4, 5, and 6. I imagine if they correlate with the warrant, then those would be the allegations at Sedano's, where the victim's name is not even mentioned in the warrant. And there is again just a statement that she's 80. We don't know how that conclusion was reached. We don't have a date of birth. Her name is not mentioned in the same paragraph as the allegation itself. Her name is not mentioned in her age is not mentioned in the body of the affidavit. So again, as to those charges, I would state that there is no probable cause to establish that the victim in these charges was 65 years of age or older.
Thank you. Court previously is going to keep their ruling, previous finding of probable cause, and adopt Judge Bailey's probable cause. Ma'am, I'm going to leave the bonds that are set in place, no return to home goods, Sedano's, no victim contact, direct or indirect with DS, DN, AR, GPS level 2. I'm doing a curfew, 6 p.m. to 6 a.m.
I also do
Thank
not see
you.
probable cause to establish count 7, Your Honor, the petty theft. There's no indication in the documentation provided to the court that she has any prior petty theft convictions. The statewide prosecutor has mentioned that, but has failed to provide the court with any documentation to that effect. We do not know if Ms. Johnson has prior theft convictions to make this petty theft a felony, and I don't even see a petty theft. So I would argue there's no probable cause for count 7.
Court's going to adopt their previous finding. Keep the same ruling. Thank you. Have a good day. Annette Ward, please.
North Broward, hours.
North Broward. Okay. By the way, when we get to Mr. Shade's case, I got a call that he said just let it go forward because she has a no bond hold. So I'm just going to set it for a $1 bond when we get
Is
to
that
it.
Miss Middleton, Judge?
I think it's Knowles.
Okay.
So,
Middleton would be, okay,
yeah, this is Jara McLawrence.
right, Miss Middleton.
Yeah,
would be
all
Miss
right, so we'll
Middleton.
pass.
Okay.
Wait, it's a medical reset? No,
Annette Ward.
Annette Ward's a medical reset. What about Marlene Middleton? She's not a medical reset, is she?
She's a municipal ordinance.
No, I know, but is she a medical reset?
That I do not know.
All right, we'll just pass her. Alicia Asbel,
Miss Asbel is in North Broward, Judge.
thank you.
Sorry.
I thought you called, was Annette Ward a reset?
I'm passing.
Okay,
No, Annette Ward is a medical reset,
Okay.
North Broward. Marlene Middleton is an MO for Mr. McLawrence.
And Miss Middleton, Judge, is here at Maine. Do you want us to bring her back at 1 o'clock, or?
No, we're waiting for Mr. McLawrence.
Oh, okay. Oh,
Okay.
Mr. Lawrence was here. He said, I believe he had to come back at 10.
Yeah, okay, thank you. Alicia Asbel.
North Broward, Your Honor.
Right.
Okay, Ms. Asbel, you have prostitution, lewdness, offer commit to engage, second offense, $300 bond. Court does find probable cause.
Just so the court is aware, Ms. Aspel is out on pretrial with a GPS. We are not asking this court to take any action on her. I show that a warrant was taken to the division judge.
Who is? You know? That's all right, it doesn't matter.
She's out on a possession, delivery of cocaine within 1,000 feet of a school and a prostitution.
Yeah, it says it in the booking report. Okay, perfect, so we'll let the division judge deal with that. All right, what say you, Mr. Reedy?
Your Honor, in speaking with Miss Asbel, she indicated to me that she has been a Florida resident all of her life. She has a friend who she believes she could stay with. I haven't had a chance to contact him yet. But if she does have a stable address and the court is not taking action on the case for which she is on pretrial release, I'd ask the court to place her on pretrial release on this charge as well. She has no money or financial ability to make any kind of a monetary bond. And her friend might allow her to stay with him, but I do not believe he's going to be able to post a monetary bond for her.
All right, because she has a pending charge and based on the totality of the circumstances, court's gonna leave the bond at 300. Thank you, ma'am. Good luck to you.
I'll call your friend for you, Alicia.
Janet Comoskin? Do we know where she is?
No, Ms. Comicskin is here present at Maine. She has private counsel Alex Ariaza.
Okay,
Yeah. Yeah.
okay. Okay,
I do have his number actually from an unrelated case yesterday.
okay. All right, well, we'll pass it just for now. Julie Marcus, Morose.
North Broad Medical Research.
Okay. Melanie Phillips, please.
North Broward.
Thank you. All right, are you Melanie Phillips?
Yes, ma'am.
All right, ma'am, you're charged with burglary with assault or battery, no bond hold for magistrate, grand theft between $300 and $5,000 bond, and battery on a person 65 years of age or older. Any objection to probable cause?
There's no mention of the age of Miss Phillips' mother in the probable cause affidavit. So that would be to count 3.
Or mention the age?
Yeah, no, I agree, Your Honor. I have no objection, no PC on count 3.
So when do you wanna,
Can I let the court know when we're done with the hearing, if I want 24 hours or not?
sure,
I don't know if I'm going to, depending on the court's rulings, ultimately.
okay. All right, so court does find probable cause on counts 1 and 2. Go ahead, state.
Your Honor, I am going to be seeking a no bond hold on count 1 upon a finding of proof evident or presumption great, relying upon the probable cause affidavit, considering this was the alleged victim's home.
Okay,
We would object to the court making that finding at this time based on the probable cause affidavit submitted by the state. The alleged victim in the case is Miss Phillips' mother. My understanding is that Miss Phillips was actually living at that residence at that time and did have authority to come inside the residence, and that her mother does not want to press charges. Assuming that those things are true, then there is no proof evident presumption great here. I mean, that's the highest standard that we have in our criminal justice system, Your Honor, higher even than proof beyond a reasonable doubt. The fact that there is a relationship like this between the two of them would, I think, in and of itself give rise to an argument that proof evident presumption great should not be held at this stage of the proceedings. And I would ask the court to set a bond for Miss Phillips. I don't know how much of a bond, quite honestly, she's going to be able to afford. But she did indicate to me that she would be able to stay with her father, so she would not be having any kind of contact with her mother during the progress of this case. So I would ask the court either to find no proof evident presumption great and set a bond, or use your discretion and set a bond. I think as these things turn out, it may turn out that this is not exactly what it seems. And to hold Miss Phillips without the possibility of bonding out until that determination is made, I think would be contrary to the interest of justice. And again, this court certainly can use its discretion to set bond. Ms. Phillips indicated to me that she's been living at this house for 20 years, and she's been a resident of Florida for 35. And if those things are correct, then that would certainly negate the state's argument that she should be held without bond.
Your Honor, the only sworn evidence before the court at this point is the sworn, and it mentions that the victim provided a sworn statement where she advised that Melanie Phillips does not live there and had no authorization to enter the residence. I would also note that in the officer's sworn report, the victim expressed her wish to prosecute.
All right, I've reviewed the probable cause affidavit Ms. Phillips filed in your case, and I find probable cause. I further find the proof of guilt to be evident on count 1 or the presumption great. I'm going to also find probable cause on count 2. Therefore, on count 1, you're going to be held no bond until further order of the court. This order, ma'am, is without prejudice for you to file a motion to set bond with your assigned division judge. Request a hearing under State v. Arthur. As to count 2, do you want to be heard with regard to the $1,000 bond, Mr. Reedy, or just?
Your Honor, I'd ask you just leave that in place.
All right, no victim contact, direct or indirect, and I'm going to ask that you maintain 1,000 feet minimum from the alleged victim, your mother, with the initials LLP. Court also is on count 2, going to do a GPS level 2. And count 3, the court's going to find just simple battery.
Your Honor, I'm fine with just no PC, and I'm not going to ask for any time on
Okay,
that.
per state and defense. Assuming you're not arguing with that, Mr. Reedy.
I'm sorry, Judge?
I'm sure you're not arguing with no PC on count 3.
No, we'll accept the state's concession as to that charge, Judge. Don't say anything, Ms. Phillips. This fight is just beginning, not ending. So don't say anything you're gonna regret later.
Okay, so Ms. Patrice, GPS level 2 on count 2, okay? Okay, thank you very much, ma'am. Good luck to you. Brielle Nelson, please.
Paul Ryan, Judge.
All right, Ms. Nelson, good morning, ma'am. You have violation of probation for a felony. You have a no bond hold. You also have a capious traffic. Is that a $500 bond?
Yes, ma'am.
$500 bond. Operating without a valid license. The court does find probable cause. You are going before your division judge, Michael Lynch, I'm sorry, on 12/3, which is this Monday at 8:30, and then you're going before Judge Cal Evans on Tuesday at 9 a.m. for count 2, the operating without a valid DL. Thank you, ma'am. Good luck to you. Next one is Ashley Nicholas.
Broward, Your Honor.
Ms. Nicholas, good morning, ma'am. You have grand theft between $300,000 and $5,000 bond. Count 2 is utter a false instrument fraud, $1,000 bond. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the name of Maria Fig. And no return to the Bank of America, ma'am, located at 1701 West Hillsborough Boulevard in Deerfield Beach. If you go back there, you will be arrested. What say you, defense?
Judge, I'm gonna ask you to consider releasing Miss Nichols on her own recognizance. She's been a resident of the state of Florida since 1991. And as I understand it, she has no prior criminal history. Oh, actually, first, we wanted to know if bond had been posted for her.
Court does find probable cause, by the way.
Ms. Nichols believes that a friend of hers might be posting her bond, but she's not at this point at all certain of that, so I would ask in the abundance of caution, in case for some reason that bond is not posted, that the court consider releasing her on her own recognizance.
And, Your Honor, I'd ask, if the court's inclined to release her non-monetary, I'd ask for pretrial. She has a pending theft out of, that predates these allegations out of West Satellite for Judge Levine.
Ms. Nichols, would you rather remain in custody, waiting to see if your friend is going to bond you out? Or would you like the court to place you on pretrial release, which means you'd be released without the necessity of having to post a bond, but you would have to check in with pretrial release and call in a couple of times a week or whatever the judge thought was appropriate?
I'm not sure. What's the best way to go?
Well, I mean, if your friend doesn't bond you out, then you're going to be sitting there. So it depends on how much confidence you have in your friend to post your bond.
I think she'll bond me out.
Okay, then I'd ask the court to leave the bonds in place.
Okay.
I'll call her and make sure that she is bonding you out, okay, Ashley?
Thank you.
Okay, good luck.
Thank you. Good luck to you. Let me know if it doesn't work out, Mr. Reedy. Tamisha Brown? Tamisha Brown.
She is here present, main judge, and she's approaching.
All right, good morning, Ms. Brown. You have possession of cocaine, $1,000 bond, count 2. Possession of cannabis, 20 grams or less. Court does find probable cause. Studio 6, a hotel or a motel or? Mr.
I don't know.
Right, court's gonna order no return to Studio 6, located at 5625 North University Drive, in Coral Springs, Florida.
It's a motel, Judge.
Okay. What say you, Mr. Romero?
Judge, nothing to add. She gave me the phone of her friend. I intend on calling her right after court.
Okay, perfect, thank you.
Still open?
Dana Allen, we're gonna get to yours soon, Mr. McLawrence.
Miss Dana Allen Moon is here present. Come on up, ma'am. Oh, sir, sorry about that. Morning.
All right, Mr. Moon, good morning, sir. You have trespass at Publix. Court does find probable cause. Court's gonna order no return to the Publix, sir, located at 402 East Dania Beach Boulevard in Dania Beach. It says he was previously trespass warned from this location on 12/29/2018. 10/29, so it's a month later and he's back there again. Court finds probable cause. What say you, Mr. Romero?
Judge, in speaking with Mr. Moon, he advised me that he promises not to return to that location. He wishes to resolve the matter today.
Does he need any assistance with where he lives, or? Okay, what say you? So does he want to resolve his case today?
He does, Judge.
Okay.
Offer would be 3 days, Your Honor.
3-day adjudication, 3 days Broward County Jail, no return.
He wishes to accept the state's offer, Judge.
How does he want to plead? All right, adjudication, 3 days Broward County Jail, credit for time served, $293 in court costs, no return to Publix. Thank you, sir, good luck to you. 6 months to pay, partial payments accepted. John David Noland. Mr. Noland, you have trespass, other structure, or conveyance and possession of drug paraphernalia and ingest. Court finds probable cause. You're going before Judge Jill Levy on Monday at 9:30. What say you, Mr. Romero? $500 bond total.
Nolan, he wishes to resolve this matter today.
Your Honor, the documented offer from the assigned Assistant State Attorney is a withholding court costs.
And no return to where?
Just one moment, Your Honor.
And this is one case, right?
Yes, it is.
Okay,
It is no return to Sensation Adult Video at 106 South State Road 7 in Hollywood.
all right, sir, how do you want to plead to trespassing other structure, possession of drug paraphernalia, ingest or inject? Guilty, not guilty, no contest.
No contest.
All right, Mr. Reedy, you spoke to him, I'm sorry, Mr. Romero. You spoke to, Mr. Noland about the $293 in court cost and what happens if he doesn't pay it?
Yes, Judge, I have it.
All right, you understand, Mr. Noland, you can't return to Sensation Adult Video.
No.
Yes?
Yes.
All right, withhold court costs on count 1, 293, 6 months to pay, partial payments, court takes judicial notice of time served on counts 1 and 2. Count 2 is a withhold. And no return, sir. Thank you, good luck to you. Trevor Worthington.
Mr. Worthington is here. Our main judge, he's approaching.
Okay, Mr. Worthington, good morning, sir. You have trespass after warning, $500 bond. You actually have 3 capiases. Counts 2 and 3, failure to register a vehicle, suspended driver's license. First offense, you're ROR'd on those, so we only have count 1 to deal with today as far as bond. Court does find probable cause. You're going before your division judge, Judge Michael Gottlieb, on Monday at 9 a.m. Court notes it says he was identified through, the police officer recognized him from a previous incident. What say you, defense?
Judge, seeing Mr. Worthington earlier today, he wishes to resolve these matters today.
One moment, Your Honor. The offer would be adjudication, time served on count 1, withholds on 2 and 3.
He wishes to accept the state's offer, Judge.
All right, sir, Mr. Worthington, how do you want to plead to those 3 charges? Guilty, not guilty, no contest?
And no contest. Judge.
And Your Honor, it's the no return is to Publix at 3500 Davie Boulevard in Fort Lauderdale.
Hear that, sir?
Yes, ma'am.
If you go back there, you'll be
Yes, ma'am.
arrested. It includes the parking lot and the curtilage of the property and the sidewalks, you understand?
Okay.
Yes?
Yes.
All right, adjudication on 1, court cost $293, 6 months to pay, partial payments. Counts 2 and 3 are withholds. Court takes judicial notice of time served in the Broward County Jail. Okay, Mr. Romero, did you explain to him about the $293 in court costs? What happens if he doesn't pay?
Yes, Judge.
All right, so no return to the Publix, and the court will dismiss the 3 traffic infractions. Okay? Thank you. The only reason I'm doing that now is because it's part of the case. If you look on this, in the docket, it has a printout and it tells you which 3 tickets. Okay, thank you. All right, William Capasso.
He's here, present, Judge.
Okay, Mr. Capasso, you have trespass, failure to leave property upon order by owner, $25 bond, no return to, it's the entire Coral Ridge Mall, located at 3200 North Federal Highway. You go back to the mall, including the parking lot, sir. and the sidewalks connected to the parking lot, you will be arrested. Do you understand?
When I take the bus there.
Well, then you'll have to take it somewhere else, sir. Go to the next bus stop, okay? No return to the
And you
court.
can fight these allegations, and if you're found not guilty, then that order would
Mr.
no longer be in
Romero, I'm
effect.
not finished. Please wait, okay? Sir, you're not to return.
I thought you were, Judge.
No. You're not to return to the Coral Ridge Mall, as I stated. Court does find probable cause, bond set at $25. What stay you?
Hold on one moment, Judge. He wants to resolve the matter and accept the court's condition as far as no return to the whole entire mall and its curtilage and its sidewalks.
Okay,
Your Honor, just to let the court know, I'll make an offer, but it's gonna involve an adjudication. Mr. Capasso is a registered offender, so the court would need to advise him that accepting, whether it's an
You'd be subject
adjudication
to the
from the
Jimmy
state or
Rice
if Your
Act?
Honor, exactly, yeah.
okay.
Involuntary civil commitment, yes.
I know what it is.
No, I know, I wasn't saying it for you, Judge,
Okay,
I know you do.
all right. All right, can your client afford to pay the bond, or does he want to resolve the case?
Judge, he can't afford the bond, he's homeless, I'd ask for an ROR at this time.
What's his prior history?
I mean, this, from what I can tell, the significance was the underlying offense that caused him to be registered. That was in
Okay.
94, sentenced to 9.5 year state prison. He's got, getting hits out of California.
All right, this is what I'm gonna do. I'm gonna put him on standard pretrial supervision. Let him report within 24 hours of being released. Let him call in 4 times a week, no reporting in person except for the first time. Okay?
Yeah.
No bond required. Thank you, sir. Good luck to you. Okay, Ruben Nault. Good morning. And then we have someone else of yours. We'll do
Marlene Middleton.
Marlene Middleton after that, okay?
Yes.
I don't think, do you have anybody else?
No, that's it, Judge.
Okay, perfect.
Mr. Note, you could come up.
Mr. Knoll, your attorney.
Thank you.
Do you-
Okay, Mr. Knoll, you have, good morning, sir. You have 3 municipal ordinances. Possession of drug paraphernalia, panhandle, false name to law enforcement. All right, so obviously, it's going up to people in the Broadway, had up a sign, and they found crack pipes on them. All right, so $100 bond on count 1, court finds probable cause. What say you, Mr.
Lawrence.
Lawrence?
Judge, I spoke with Mr. Nold. I explained to him that I felt that I have been filing motions to declare the panhandling statute unconstitutional. And also, if you read the complaint affidavit, it states in there that he gave the officer the name Ruben Nold without the E. And then his real name has an E in it, and that's the basis of the false name to law enforcement officer. Regardless of that, Judge, I explained to him that he has the right, if he wants me to fight that, I can fight it for him. He told me he doesn't want to do that. He just wants to resolve these cases here today. He told me he's homeless, and I explained to him about the Henderson CRC. He told me he would like to take advantage of that if he could.
All right. Well, I just want to note, I don't know what's going on with this panhandling statute, what the status is, at least I haven't seen anything. But it is the law, and the court's concern is, it causes vehicles to slow down. It's a hazard. Someone could hit him, something could happen. So I'm gonna order no return, regardless of what we do today, to Northwest 7th Avenue and Sunrise. And sir, as of now, you're not allowed to panhandle. I mean, that's the bottom line. So maybe you can use the services of the CRC. I think it's a great place to give you an opportunity. So the court will do an adjudication and time served. An adjudication and time served on counts 2 and 3, and count 1, the court will do a withhold. And $78, Mr. McLaurin's in court costs. Is that what he wants?
That is what he wants to do.
All right, thank you so much. All right, so Mr. Nolt, do you want to resolve your case today? Mr. McLaurin is telling me you want to resolve it.
Yes, Your Honor.
Did you explain to him what happens if he doesn't pay the $78 in court costs?
I will now, Judge. Mr. Nolt, if you, the court has assessed $78 in court costs, and she's given you 6 months to pay that. If you don't pay it off in 6 months, there's a good likelihood that your license will be suspended and your credit will be affected.
$25 late fee.
And there's a $25 late fee. You understand that? Okay.
All right, so how do you want to plead to panhandling, possession of drug paraphernalia, and false name to Leo? Guilty, not guilty, no contest.
I'm no contest, Your Honor.
You understand that Mr. McLaurin is saying there's defenses to this, and you could, go to court and fight this. I'll release you
Yeah,
today. Well, let me just finish. I'll release you if you want, so you can come back and fight it. Don't feel like you're gonna be held in jail, and you're gonna sit in here until you have a trial. That's not gonna happen. You understand that?
Yes, Your Honor, but because my situation with being homeless, everything's just so crazy for me, so it would be really hard for me to, I'm afraid I wouldn't make it to the,
Your court date?
yes, ma'am, yes.
All right, so you feel it's in your best interest to resolve it and plead no contest?
Yes, Your Honor.
All right, so withhold on count 1, court costs $78, 6 months to pay, partial payments accepted, counts 2 and 3 are adjudication, and time served. No return to Northwest 7th Avenue, Sunrise, and no panhandling. Thank you, sir, good luck to you.
Thank you, Your Honor.
All right, Marlene Middleton. Oh, okay.
She's in the main jail, Judge. She's coming up.
Right there. Thank you.
Two. I just was making sure they're all filled out. Okay. All right, good morning, Ms. Middleton. You have a habeas misdemeanor for possession of paraphernalia. Can I see Ms. Middleton back?
I'm here.
One moment, ma'am. Yeah, I just want to see you for one moment. Sorry. All right, so your attorney, Mr. McLaurin, is telling me you want to resolve your case today and plead guilty or no contest?
No contest.
All right, adjudication, time served, $78 in court costs, 6 months to pay, partial payments. Mr. McLaurin, did you explain to Ms. Middleton what happens if she doesn't pay the court costs?
I did not, Judge.
Okay, can you explain it to her?
Sure. Ms. Middleton, the judge has assessed $78 in court costs and given you 6 months to pay that. If you don't pay it in 6 months, there's a good likelihood that your driver's license will be suspended. You'll be assessed a $25 late fee,
Thank you, Ms. Patrice.
and your credit will be affected. You understand that?
Yes, sir.
Okay. All right, adjudication, time served, $78 court costs, 6 months to pay, partial payments accepted. Thank you, ma'am, good luck to you.
Thank
You're
you.
welcome, Mr. McLaurin. Have a
Judge,
good
you
day.
can recall Miss Comason on page 2 if you like as well.
Okay, what's happening with that?
I spoke with Mr. Ariaza's office. They have not been retained on this case.
Okay. Where is she? Main jail?
She is at the main jail.
All right, thank you. Okay. All right, good morning, ma'am. So you have a capious misdemeanor for a violation of an injunction order, stalking or cyber stalking. Your judge set your bond at $500. Court does find probable cause. However, the alleged victim's initials and name are redacted from the probable cause affidavit I have.
I can get that for you, Judge.
Thank you. All right, so no victim contact, direct or indirect, with the alleged victim in this case. I'll give you the initials in a moment, ma'am. Court finds probable cause. What say you, Mr. Mr. Romero, I'm sorry.
Judge, she gave me the phone number of her son. I intend on calling him right after court.
ACW.
Okay, no victim contact, direct or indirect with ACW. Anything else?
No, nothing further.
All right, $5,000 bond. Thank you, Mr. Romero. Good luck. Ma'am. Jocelyn Pierre Louise.
Here, Banks.
Okay, Mr. Pierre Louise, you have operating without a valid DL and $25 bond. Count 2 is failure to yield to pedestrian when no signal. It's actually not for magistrate. Court does find probable cause. What say you, defense?
Mr. Pierre Lewis wishes to resolve this matter today.
Time served, Your Honor.
Adjudication, time served. If he wants to take it, how does he want to plead, Mr. Romero? All right, did you explain to him about the $293 in court costs?
Yes, I did.
All right, so adjudication, time served, $293, 6 months to pay, partial payments accepted. Thank you, sir. He still has the failure to yield the right-of-way charge. Xavier Sosa.
Mr. Sosa, come on up.
Mr. Sosa, good morning, sir. You have unlawful use of false name, bond set, $250. He no-showed at arraignment May 14, 2018. Court finds probable cause for the capias for his arrest. What say you, Mr. Romero?
Judge, it's me, Mr. Sosa. Unfortunately, he's homeless. He's 62 years old. However, he did say that he has a mailing address at a shelter that he receives mail at in Fort Lauderdale. He doesn't have the exact address. He thought that was the address that they were going to send him a notice at. Having said that, Judge, we're going to be asking for an ROR. I was also talking to him about the centralized receiving center that they system in getting housing. He would be interested in that as well. So I'm going to be asking the court to enter an order allowing him to be released ROR and an order having him picked up tonight at 9 o'clock to go to the centralized receiving center.
One moment, judges. Your Honor, I can tell you, I'm looking, because you actually ROR'd him in a second look, and you wrote an address down for,
Well, I'm not gonna ROR him then. You know what? So, I tell everybody how to look it up. So, you know what? I'm gonna leave the $250 bond in place. Thank you, sir. Good luck to you. You'll see your judge on Monday. Tyler Peters. Mr. Peters, good morning, sir. You have disorderly intoxication, public place, causes disturbance. $25 bond. Court does find probable cause. Court's going to order no return to the Publix at 1003 East Commercial Boulevard in Oakland Park. What say you, Mr. Romero? Does he want to resolve his case today?
Guys.
Okay, State, you have an offer?
yes, Your Honor, I just need one moment to. Your Honor, he has no history. The offer to be a withholding, as you already mentioned, no return to this Publix.
Okay, Mr. Romero, how does your client want to plead?
No contest.
All right, is that what you want to do, sir?
Yes.
All right, withholds court costs $293, 6 months to pay. Partial payments, no return to the public. If you go back there, sir, you'll be arrested, you understand?
Yes, ma'am.
Did you explain to him about the $293, Mr. Romero?
I did, Judge.
All right, thank you. Good luck, sir. Oh, court takes judicial notice of the time that you served in the Broward County Jail. Okay. Next one is Clarence Polk, please.
Conte?
Okay. All right, Mr. Polk, good morning, sir. You have an ad charge.
Good morning, ma'am.
This is for possession of substituted cathinones. It's actually a change of charge. Then it says an ad charge, so I don't know. Do you know which one it is, State?
It's a change of charge, Judge.
Okay, that's what I thought it was. All right, so change of charge, count $3,000 bond, court finds probable cause. You are going before your division judge, Judge Thomas Coleman, on Monday at 8:30 a.m. What does he have on counts 1 and 2?
No bond hold on count 2, Judge.
All right, so leave it in place.
Yes, please.
Thank you.
Judge,
Yes,
ma'am,
sir.
you say, even if I bond it out on this,
You have a no bond hold, sir.
okay, all right, so,
You want to tell him what he has a no bond hold for, so he's
It's
seems
a
a little
felony
bit in the
theft.
dark here.
It's a court ordered no bond hold on a felony theft, sir.
Okay. All right, sir, do you understand? Do you want time to talk to your attorney, Mr. Reedy?
is he around?
Yeah, he's around.
Yeah, I'm right here.
Sir, thank you. Can I get your number, please? I have a court-appointed attorney for the other.
Yep, well, I'll let your court-appointed attorney know that you're where you are, and that's the person you need to talk to.
What's his name?
I'm looking it up right now.
He won't pick up
I'm
the
showing-
telephone, sir. He won't pick up the telephone. I've been
Your
trying to
Honor?
get in contact with him repeatedly.
Everybody, wait.
Do you have a name, Mr.
Well,
Reedy, we can give him?
It's not it might not be a PD, Your Honor. The PD's office withdrew.
No, he's not a PD. He's,
And it's
Regional
Phil-
conflict?
I don't know that it's regional conflict. Philip Massa,
yes, that's his name. He's in Palm Beach.
He's a private attorney?
Yes.
All right, well, do we know if he has a court date
on that case,
on the case? Yeah.
the no bond, it's,
I see a December 3rd court date.
All right, so you're gonna see him Monday on December 3rd, and if you can't get in touch with him, address it with your felony judge then.
I believe, it might be December 3rd on this case. The felony theft that he's being held no bond, he has a calendar call scheduled for the 17th.
Is this ad charge part of that case?
No.
No.
That's why I just,
What you mean ad charge, Judge?
it's a,
I mean, I for the,
Or change of charge.
possession of substance. What is that possession of substance? What is that?
All right, sir, these are questions you're gonna have to ask your attorney, but you are going to court on Monday. You can ask the judge at that time, okay?
Okay.
All right.
All right, thank you, Your Honor.
No return to the public, sir. Thank you. Good luck. Richard Graham,
Conti.
good morning.
Good morning.
All right, Mr. Graham, you have driving while licenses suspended or revoked, change of charge, you're ROR'd. So you'll see Judge Usan on Monday.
Okay.
Thank you, sir. Good luck.
All right. You too.
Do you want to call
Thomas
Mr.
Warren.
Mooring, Judge? Do you have that paperwork on him in
Yeah, he's
between
in-
Polk and Graham?
Why, is it mixed up? 'Cause he's
It might
next.
have.
All right, well, he's next.
Mooring would be after
no,
Polk.
there's, Your Honor, you're referring to Mr. Morin, Morin. Mr. Reedy's referring to John Moring.
Yes, that's correct. That is correct.
Mohring.
Did he bond or something? Because I don't,
No, he's in Paul Ryan. He refused.
we just did Graham.
Maybe
And then I
Before
have
Graham would
Paul.
be Mooring.
maybe got attached to another. John Francis Mohring.
Was that the one with, don't know, let's just save it to the end. Is there an extra paper attached for this gentleman they're asking about?
John Francis Moring,
What page are we on now with Thomas?
12.
12.
And what page was this other gentleman?
12. His case was immediately after Mr. Paulk's on the docket.
Well, let me just see if it's attached somehow. No, this is Mr. Paul. I don't have it. Sorry. All right, give me the spelling again.
Moehring.
Hering. What's the first name?
John.
All right, it's probably somewhere in this package. Probably
Okay.
just out of place. Okay, Thomas Moran, please.
North Broward.
North Broward. Good morning, are you Thomas Moran?
Yes, ma'am.
All right, sir, you have grand theft between $300 and $5,000, count $3,000 bond, count 4 is dealing in stolen property. Court does find probable cause. This is Billy Goings, we had him yesterday. Court's gonna order no return to the Home Depot, sir, located at 1701 West Oakland Park Boulevard in Oakland Park. Court finds probable cause. What say you, defense?
Your Honor, unfortunately, Mr. Moran has a no bond hold on count 2. I'd ask the court to leave the bonds in place or reduce them if the court feels that's appropriate.
Okay, I'll just leave the bonds in place and no return to the Home Depot. Good luck, sir. Next one
Thank you.
is David Rice. I'm sorry, North Broward. Thank you. All right, Mr. Rice, you have stalking, following, harass, cyberstalk another, burglary, occupied dwelling unarmed, state of emergency. Let's see the date here. So we'll take out the state of emergency, correct?
Yes, please,
State?
Judge.
Yes, ma'am.
Okay, and 4 is stalking, follow, harass, cyberstalk another. These are add charges, 2, 3, and 4. Court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials D, M, G. Court notes, it says David Rice served a 5-year state prison term for burglary of a dwelling occupied and aggravated stalking. It's 2009 case from the same victim and was released on September 3rd, 2018. Says he was arrested on November 10th from the same victim, and he was released on bond and found to be inside the victim's residence on November 19th. I have November 10th. Same place again. Court finds probable cause. What say you, state?
Good morning, Judge. Anna Lopez on behalf of the state.
Good morning.
The state would recommend a $15,000 bond on count 2 and 4 and a $25,000 bond on count 3 due to the safety concerns with the victim.
So
And level 2
15 I'm sorry,
GPS.
15, 15, and,
25.
okay,
And level 2 GPS.
okay. And no return?
Yes, Judge.
And the address of no return, please?
Your Honor, would it be okay, if, just because of the sensitive nature of the allegations, Your Honor, just, if maybe Mr. Reedy could provide that to.
You talking
So
about
you
the
wanna
name
give
of
me
the
a
alleged
street?
victim?
That's, oh, absolutely, yeah. That's fine.
I don't think we need to do
Just the
that.
suite?
Do what?
I think that, Mr. Rice and I discussed the situation. He knows who the person involved is.
All right, well, it's DMG, so,
Your Honor, obviously, I obviously take Mr. Reedy at his word, so the state is satisfied.
I honestly, I do not see probable cause, though, in the documentation that I have for cyber stalking. I've got kind of a conclusory probable cause affidavit, and I don't see. Let me just have 1 second, Judge.
Judge, were you still looking for paperwork for John Moore?
yes.
Okay, I found it, Gary.
And as the court's aware, cyber stalking is only part of the statute. I mean, I know it states that, but it doesn't require cyber stalking to satisfy the stalking statute.
Okay,
I'm not going to, I just reviewed the probable cause affidavits in the cases. I'm not gonna make a probable cause argument. Mr. Rice is being held on a $25,000 bond on count 1. He's not gonna be able to post that. I'd ask the court for a $5,000 bond on each 2, 3, and 4.
victim contact, direct or indirect with DMG, no return. State per state, don't state the address. Your attorney should provide that address to you, sir. GPS level 2, curfew 7 PM to 6 AM. 15,000, 15,000, 15,000. Thank you. All right, let's go back to John Mowring. Pardon? 1 mile. Sir, 1 mile distance. John Mowring, where are they?
Refused, Judge. He's in Paul Rhine.
All right, so defendant refused.
He has a no bond hold on counts 1, 2, 3, and 4. I'd ask the court to leave the $750 bond in place.
Okay, court's gonna order no return to the Publix located at 4901 Sheridan Street, Hollywood, Florida. Court finds probable cause for this ad charge of petty theft, 2nd degree, 3rd subsequent offense. Defendant refused and voluntarily absent himself from magistrate court. $750 bond. Thank you. Frank Cadet, please.
Mr. Cadet is here present, main judge.
Thank you. All right, Mr. Cadet, good morning, sir. You have shoplifting, retail theft, $300 more or less. Oh, this is the one with a bunch of them. So you have grand theft counts 22 to 25 is grand theft between $300 and $5,000. Court does find probable cause. Court's going to order, sir, no return to Bed Bath & Beyond at 1801 South University Drive. Lowe's Home Improvement, 11620 State Road 84, Davie, Florida. Lowe's Home Improvement, 11620 State Road 84, Davie. And Lowe's Home Improvement, it's the ones that I just said. Same address, 11620 State Road 84, Davie. So no return to Bed Bath & Beyond and Lowe's. Anything further with the $1,000 bond on each count? Mr. Romero, Mr. Reedy?
No, Judge, I'm just gonna ask for a photo order.
Sure, no problem. Get
What
me
type
a
of
photo
order, I'm sorry?
Photo.
Photo, okay.
Thank you, sir. Good luck to you. Michael Sinsheimer.
Calling up, sir.
Morning, sir. You have burglary, occupied conveyance unarmed. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials DRC. Court does find probable cause. What say you, state?
Judge, the state recommends a $5,000 bond. He has, out of Escambia County, 2018, he was Marchman acted, and in 2017 and 2013, Baker Act. He also has a warrant out of Texas, from 2017 for criminal mischief, and he has from 2017 out of Colorado, damage to private property.
So you said Texas and Colorado?
Yes, Judge.
Okay. All right, what say you, defense?
Judge, how do you pronounce your last name? Sensheimer. Mr. Sensheimer is 32 years old, Judge. Right now, unfortunately, he's homeless. He's looking for work. From what he informed me, the last time he had any sort of felony conviction was over 10 years ago. Judge, he's not in a financial position to post any sort of monetary bonds. Third-degree felony, I'm going to be asking for a $1,000 bond.
$1,000 bond, no victim contact. Thank you, sir. Good luck to you. Joseph Louis Francois.
Mr. Francois, come on up, please.
Okay, Mr. Francois, you have sell heroin, $50,000, distribute or deliver fentanyl, $50,000, sell heroin, $50,000, distribute or deliver fentanyl, sir, $50,000, 5, 6, and 7 are possession of a weapon or an ammo by a convicted Florida felon. And count 8 is trafficking cocaine between 28 and 200 grams, $15,000 bond. 9 is possession of cannabis over 20 grams, $1,000 bond. 10 is trafficking in heroin between 14 and 28 grams, $250,000 bond. Count 11 is trafficking in fentanyl between 14 and 28 grams. Any objection to probable cause? Hearing no objection.
No, not at this time, Judge.
Court finds probable cause on all counts 1 through 11. What say you, state?
One moment, Your Honor.
She kept these, so I'm asking for these.
Your Honor, the state is going to be recommending on counts 5, 6, and 7 that the court set the bonds at $10,000 each, that the court keep all the other bonds in place, including the bonds that were set by Judge John Murphy. Your Honor, additionally, we'd ask that the court keep on counts 1 through 4 the special release conditions that Judge Murphy set in place. We'd also request that Your Honor apply those special release conditions to the remaining counts that weren't part of the warrant.
Say that again?
We'd also request, if the court is inclined to keep the special release conditions that Judge Murphy set in place, that they also be applied to the remaining counts that weren't part of the arrest warrant.
Okay.
Your Honor, I would note, obviously, these are very serious charges, especially when combined with the allegations in the arrest warrant, with the evidence and that was found pursuant to the search warrant. I would also
So you're
note,
not saying a warrant, these are only search warrants, correct?
let me clarify. Combining the charges on 1 through 4 from the arrest warrant, and then the allegations from the remaining charges that were as a result of the executed search warrant. Yes, yes, ma'am.
All right.
Your Honor, I would note
I don't have a copy of any of those orders.
this special, you know, this special release condition, Judge? Here, I'll provide you.
Do you have it, Mr. Reedy?
Do you have the arrest warrant, Judge? No. It should be on the second page of with the bonds that were
It's
set.
page 2 of 3,
I don't have the actual
asking
warrant.
for a Nebbia hearing,
I don't have any of that.
Just one moment, Judge.
Okay.
surrendering passports.
I don't have any affidavits to arrest or anything.
Oh, you don't have any part, okay.
All I have is a PC. I have the booking report.
That's weird. Usually if I have the warrant,
Yeah.
then you do, but I'll print it out for you, Judge.
I
It's
have
not a problem.
PC, which is
Oh, you know what, Judge?
four,
Judge,
5 pages.
if you look further in the docket, now I realize, for some reason, in my pile, they weren't together. I don't know why that happened.
Well, these are all under, there are more charges. I have Junior
Yo.
Robert, and then I have Junior Lewis. I have 2 different names.
Yeah, you're right, you're right.
4?
He's also on page 23 of the docket, Judge.
How many? Here, look at these, tell me what's different.
Yeah, well, that explains a lot.
I'm saying, because there's 4 there, so which one's,
What happened?
All right, well, he's not going anywhere.
No, this is not the same, it's not the same person.
it's not? All right, well, I'm sticking this one back.
There's the warrant.
This,
Yes, he's on
Yeah,
page
Junior-
23 as well.
it's Junior Robert.
Either way.
Oh, okay,
All right, let me, just give me one moment to read this, that's a separate person,
never mind.
4.
So, okay, while she's doing that.
Right.
Names are almost,
Yes.
in the charges.
Just the second part. Oh, I split them up. Then you'd recommend bonds on these.
As a result of the search warrant. Oh.
Yeah, well, but whatever the result of, you recommend a bond on these because they're hold for magistrates. And then. Frankly, if a nebula is relevant on these, then it should certainly be relevant on these.
These other ones. Okay.
And then just, and it's not just the facts, and you'd also go into. Yeah, actually.
So you have this warrant, right, Mr. Reedy?
I do. That's 3 years, but these are, I think, more than 3 years.
All right. So let's start, we have all of this, you're asking $10,000 each one.
15 years.
Anything else, State?
And yes, Your Honor, also just noting first, if convicted on count 8, he's facing a 3-year minimum mandatory sentence. On count 10, a 15-year minimum mandatory sentence. And on count 11, a 15-year minimum mandatory prison sentence. I would also note in 2016, out of Dade County, he was convicted of trafficking cocaine between 400 grams and 150 kilograms, and money laundering unlawful proceeds between $20,000 and $100,000. And that's another reason why I believe the nebia requirement and full collateralization is appropriate on all charges.
So you have a passport?
He does.
Okay. All right, go ahead, defense.
Nothing to add at this time, Judge.
Something
All right, so we're gonna leave all the bonds in place. 5, 6, and 7 are $10,000 each. GPS open schedule, counts 1 through 11, Nebbia, full collateralization. Bond surrender to clerk prior to release, no possession or applying for a U.S. passport, no possession of any firearms, ammunition, or weapons. No objection by the defense to any of the conditions. Thank you, sir. Good luck to you. Did you get that, Ms. Patrice?
And Your Honor, and I apologize if you said this, just for the record, those conditions apply to all charges?
Yes,
Okay.
1 through 11, I said.
Okay, I missed that, thank you.
No problem. Michael Cheek, please. All right, Mr. Cheek, you understand if you can't afford an attorney, you can fill out an application for the public defender. It's a $50 fee. You can pay it at a later date, obviously, you don't have to pay it today. But if you want, you can have the services of the public defender, or you can hire your own attorney, or you can represent yourself. What would you like to do?
I have a public defender on this case. I was out on bond. I was at a Fair Oaks Hospital. I wasn't able to make, I was in the hospital at,
All right, so sir, why doesn't he, if your office represents him, sounds like you represent him on the felony.
That's why I came back up here, Judge.
Okay, so he has a capias felony, it's not for magistrate, actually. He's going before his division judge, Judge McCarthy, on Monday at 8:30 a.m., and the capias misdemeanor, you know what, I'll ROR him. Thank you, sir, good luck to you.
I'll email your public defender right after court.
Philip Christian Black, please.
Come on up, sir. Oh, he has private counsel, Judge. They didn't give me the time to announce any of this. Oh, okay, what's your private attorney's name, sir?
Bruce Radikoff.
Oh, Mr. Radikoff. Do you have his phone number, sir?
And then Randy
Do
Mayer.
you have his phone number, sir? Mr. Radikoff?
I have it.
And Mr. Reedy has it. Hold on one moment, sir.
Does Mr. Radikoff represent you on the petty theft charge?
Yes, Your Honor.
Hey, BR. We got a Philip Black here in magistrate court. We do. It says, you know him.
Mr. Reedy, your mic's on.
He represents him, so he can appear by phone if he wants.
Mr. Radikoff can be here in a half an hour, Judge.
Well, he can also appear by phone.
He's in front of Judge Duffy right now.
Okay. As long as he's here on time, thank you. Before we finish. All right, sir, so we'll wait for your attorney, okay? Jim's Woody Joseph.
It's approaching.
Yes.
Okay, I didn't realize, thank you. Okay, Mr. Joseph, you have operating without a valid license, $25 bond. Counts 2, 3, 4, 5, 6, 7 are capiases. Count 2, capias is 500, 3 is ROR, 4 is 300. Is it 500 or 300? Let's see. $500, I'm sorry, sir. And then 5 is ROR, 6 is ROR, 7 is 500. Count 8 is violation of pretrial. It's actually not for magistrate. You're going before your division judge. Judge Michelle Tobin Singer on Monday at 8:30 a.m. And counts 9 and 10 are also warrants for violation of pretrial by Judge Michelle Tobin Singer. Court finds probable cause. What say you, Mr. Romero?
Judge, I understand he has a no bond hold. That's what I explained to Mr. Joseph. The court cannot do anything regarding no bond holds. On the capias for the misdemeanor offense, would Your Honor consider a dollar bond?
Tell you what, on the operating without a valid DL, $1. Let me just look at the capias. No showed October 21st, November 9th, November 5th. Then he didn't report to pretrial. No. So I'll just do $1 on count 1, the instant case. Capias I'll leave in place. Thank you, sir. Good luck to you. Hi. How are you? All right. Mario Felizor, please.
Come on up, sir, Mr. Felizor.
Okay, Mr. Felizor, you have resisting an officer, obstructing without violence, $100 bond. Count 2 is a warrant for a violation of pretrial, a no bond hold. It's actually not for magistrate. Court does find probable cause. You are going before your division judge, Judge Edward Merrigan. On December 3rd at 8:30 a.m. Court finds probable cause. What say you, defense?
We're going to be asking the court to consider a dollar bond on count 1.
Dollar bonds. Thank you. Come on up. No, sit here, I'll show you the stuff. Come on up. So Craig Sidero? Okay. So, Mr. Siderio, is that how you say your name, sir? Siderio, I'm sorry, sir. All right, so you have a possession of heroin, $1,000 bond, court finds probable cause. What say you, defense?
Your Honor, this appears to be a residue case which probably will be filed ultimately as a possession of drug paraphernalia. I ask the court to take that into consideration when determining appropriate pretrial release conditions for Mr. Siderio.
Okay.
Judge, I'd ask you to take that into consideration as well, as Mr. Siderio is 31 years old. He relocated from New Jersey down here. He's been here almost 1 year. The reason why he relocated, Judge, his grandfather, who is elderly, is living down here. He came here to assist him. Basically, he's his caretaker. He lives in Margate with his grandfather. His funds are limited. Judge, my understanding is, I'm sure Mr. Lender will correct me if I'm wrong, I believe this is his first felony drug offense. And if it is, Judge, considering this would be properly filed as a paraphernalia, I'm going to ask the court to consider an ROR on Mr. Siderio's behalf.
Okay. State, does he have priors?
Start off with the warrant.
Judge, he has a warrant for violation of probation for shoplifting out of Philadelphia. And the warrant was from April 11th of 2018. He has priors out of New Jersey for theft in 2016. Possession or selling hypodermic syringes in 2016. Receiving stolen property, possession, selling hypodermic syringe in 2016 as well. Retail theft from 2016. Retail theft again from 2011. He does have a felony for ordering forged documents in 2010. He has a prior in Pennsylvania for robbery from 2017.
All right, so obviously, something's going on here, so I'm not gonna ROR him, Mr. Romero. So can he afford the $1,000 bond?
No, he cannot. So in the alternative, what I'm gonna ask is to have him released on pre-trial release. We can be supervised. If the court's not inclined, at the very least, judging by I believe the state attorney's, recent policy, is not policy, but considering this will be filed most likely as a paraphernalia, then I'd ask for a standard bond of $100 on Mr. Sideria's behalf. But I would be asking for first standard pretrial release.
All right, I'm gonna release him without the requirement for a bond. I'm gonna put him on standard pretrial supervision.
Listen.
Mr. Romero's gonna hand you a map. You're gonna report within 24 hours of your release, sir.
Okay.
Okay, today is Friday, they're not open on the weekends. You might make it by today. I don't know, they close at 5 o'clock. But you have to report, if not today, by 4 o'clock. They actually close at 5. I don't know if they'll be able to see you, but if not, by Monday, 12 noon. If you don't go there, you'll be arrested. You'll have a warrant out for your arrest. Do you understand?
Yes.
All right, so you're gonna report within 24 hours. I want you calling in 4 times a week. Normally it's 2. I'm gonna up it a little because of your prior history. And I want you to report 1 time a month in person, no reporting after court. Thank you, sir. Good luck to you.
Thank you.
We'll be back in 1 moment. All right, so next one is Malik Sherrard Perry. Malik, I'm sorry. All right, Mr. Perry, you have fleeing, attempting to elude a law enforcement officer, $1,000 bond. You have a probation violation with a no bond hold. You are going before your division judge, Judge Thomas Coleman, on December 3rd, which is this Monday, at 8:30 a.m. The court does find probable cause.
Judge, he just advised he has private counsel, Mr. Jeffrey Grossman.
Okay, what's Mr. Grossman's number? Do we have it?
Do you have his phone number, sir?
I have the office number.
Okay.
954-485-4885.
485-4885?
Yes, ma'am.
assistant might answer the phone though.
That's fine.
All right.
Case. Yes, hi, is Attorney Jeffrey Grossman in? This is Judge Malika calling for Broward Magistrate Court. I have a Malik Perry in front of me.
Okay, 1 second, please, Your Honor.
Okay. So, I called people up because I just want to move it. Sure. Right. Just get it out because sometimes you gotta let her ease it down. So, now this sometimes might say the wrong code, but for the most part. So this is MB means no bond. It's 946.
Neil is not available to take your call. Please leave a message after the tone. Press the pound. Sorry, Your Honor, I'm getting his assistant right now for you, okay?
Thank you.
Thanks.
Hello, office. Good morning. This is Neil.
Hi, Neil. This is Judge Malika from Magistrate Court. I have Malik Perry in front of me. You're on
Yes,
speaker.
good morning,
You're being
Your Honor.
recorded. Good morning. How are you?
Good, thank you, ma'am. How can I help?
All right. So, I have a Malik Sherrod Perry in front of me, and he's saying Mr. Grossman represents him. So he has a fleeing or attempting to elude a law enforcement officer $1,000 bond, probation violation, or community control. It's going before his division judge, Judge Coleman, on Monday, at 8:30 a.m.
Okay.
So, do you want to represent him over the phone? Do you want to send Mr. Grossman?
Oh, Mr. Grossman's actually not in town this morning. I can have.
So do you want to represent him
Well,
today?
I'm not an attorney. I can't.
Oh, I thought you were the attorney. I'm sorry.
Sorry, ma'am. I apologize. I'm
That's
not the
okay.
attorney, no. I can have Eric, who's an attorney in our office, stand in, or otherwise we can just go on Monday morning and see Judge Coleman.
Well, we got to magistrate him today, so why don't we put Eric who?
Okay, I'm going to get Eric on the phone right
What's Eric's last name?
now. Van Vonno. VANVONNO.
Thank you.
Okay, I'm going to transfer you now. Sorry, Your Honor.
That's okay. Now, set because you're gonna get a list every Monday, and the list helps you differentiate who's there, whether they have a new bond hold. Okay. Because you gotta set them for second notice. And you can do that if you want. You can do what you want. I just thought it's so much easier. Or they if they want, but those are the ones to help so you can gain time. Although the judge can, take judicial notice of the time that they serve. So, so now I'm going to reset this for you. I started one. So that was the start of time. I'm also going to do extraditions. Very easy. Okay. Are you excited? I am. Okay.
Sounds good.
This is Eric.
Hi, Eric Van Vonno. This is Judge Malika. I'm the magistrate judge in Broward County. You're being recorded, and you're on
Yes,
speakerphone.
All right, how are you?
Good. How are you? So
I'm doing well.
I have Malik Sherrod Perry in front of me. He is represented by Mr. Grossman, and he has a charge of fleeing or attempting to elude a law enforcement officer. $1,000 bond. Count 2 is probation violation or community control. No bond hold. He is going before his division judge, Judge Coleman, on December 3rd, this Monday at 8:30 a.m. So the court does find probable cause. Any comment as to the $1,000 bond? Or you just want to address it with Judge Coleman on Monday?
We'll have to address it on Monday. I'll just leave it at 1,000.
All right, thank you.
Thank you, Judge.
You're welcome.
Okay.
Have a good day.
You too. Bernard Thieselman. For magistrate. All right, so Mr. Thieselman, you have possession with intent to sell, manufacture, or deliver cannabis, $1,000 bond. Possession of cannabis over 20 grams, $1,000 bond. Possession of MDMA, ecstasy, $1,000 bond. Drug paraphernalia, possess and/or use, $100 bond. Count 5 as neglect a child without great bodily harm. We need to talk about bond. Court does find probable cause. What say you, State?
And Judge, if we could reset this to the PM docket, we're getting a supplemental report from the officer as to, charge number 5.
Okay, so we'll reset this for 1 PM today. Thank you. Kedrick Wimbley.
Mr. Wembley's approaching.
All right, Mr. Wimbley, you have robbery with a weapon, $100,000 bond, count 2. It's robbery by sudden snatching. Actually, it's armed robbery. Court does find probable cause. There was a warrant to arrest signed by, looks like Judge Ari Porth. Yes, it is. Court's going to order no return to the Home Depot located at 1100 Northeast 4th Street, Fort Lauderdale, Florida. Court's also going to order no possession of any firearms, ammunition, or weapons. $100,000 bond on 1, no bond hold on count 2. What say you, State?
Your Honor, on count 2, for robbery firearm,
Yes.
punishable by life offense, the state would be requesting that the court make a finding of proof evident or presumption great,
Okay.
and order for first appearance purposes only, and order Mr. Wembley to be held no bond on that count.
Okay. What say you, defense?
Judge, I've reviewed the affidavit on the case. I would ask the court not to make a finding of proof evident presumption great at this time. That is the highest standard of proof that we have in the criminal justice system, higher even than proof beyond and to the exclusion of every reasonable doubt. Based on what's been submitted to the court, I submit that the evidence is insufficient to reach that standard. I'd ask you to set bond for Mr. Wembley. If the court, over our objection, does find proof evident presumption great, I'd ask the court to exercise its discretion and set bond for Mr. Wembley in this charge.
All right, so Mr. Wembley, on count 1, $100,000 bond, count 2, I've reviewed the probable cause and affidavits filed in your case, and I find probable cause on that count as well. I further find the proof of guilt to be evident on the presumption great. Therefore, on count 2, you're going to be held no bond pending further order of the court. This order serves without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. On count 1, the court is going to do a GPS level 1. And the court's going to require you maintain 1,000 feet minimum from the Home Depot. Any no victim contact, State?
Your Honor, I think if the court orders no return to either locations, that would suffice. If I may just, it's a matter of housekeeping. On your findings, on
Yes.
count 2, does it say sudden snatching?
It says robbery by sudden snatching
Okay.
with a firearm or weapon, but it says armed robbery on the
Yeah.
booking report.
If the court could write in robbery with a firearm, I imagine this might come back eventually on a change of charge technicality. So I would just want, in case you're not here, the
Okay.
original findings will reflect.
Okay.
Thank you.
So you want me to say robbery with the firearm or armed robbery?
I think robbery with a firearm is more specific to the allegations.
Okay. So I'll just put robbery. So it's clear.
Because what will happen is, right now, as far as the court is concerned, it's robbery. So when we file robbery firearm, it's going to automatically change.
Thank you. Mackinson Marius.
private counsel, Mr. Jim Lewis.
Okay. Has anybody contacted Mr. Lewis? Hello. Who do you have? Oh? Did we do him already? We did him already.
Oh, okay.
So let me tell you what we did.
I understand it's a pretrial release warrant.
Yep. Well, that's not for magistrate. He has $1,000 bond on the capious misdemeanor.
He's still sitting there, Your Honor. Judge, Mr. Black's right there.
Okay. All right, can I get the other paperwork back? I probably gave this to you by mistake.
Can I get your paperwork back for Philip Black?
Okay, so Mr. Black, do you see your attorney, Mr. Radikoff?
Yes.
Good morning, Mr. Radikoff, nice to see you.
Good morning, Judge. Thank you. Good to see you.
All right, you have capious misdemeanor, petty theft, $1,000 bond, count 2 is a warrant for a violation of pretrial felony. You have a no bond hold that's actually not for magistrate. You are going before your division judge on that charge, Judge Michael Lynch, on December 3rd at 8:30 a.m. Court does find probable cause unless I hear an objection. What say you, Mr. Radikoff, on the $1,000 bond?
Judge, I obviously have no objection to the $1,000 bond. I'm just worried that these cases, I represent Mr. Black on a burglary and a petty theft case presently. I'm just trying to determine if these are those cases.
He gets arrested and he's incarcerated.
Yeah, I've filed notices on both those cases. I thought that the no bond warrant would have been out for the violation of pretrial release.
It is.
Okay. So we have bonds on the burglary and petty theft.
No, all we're here for today is a capious misdemeanor in case number 181671 MM 20A. That was originally before Judge Hurley. He failed to appear. Judge Hurley issued a bond October 25th, 2018 for $1,000.
Other burglary charge?
No, it's,
I mean, other,
it's the same burglary.
okay, I mean, another petty theft charge.
No, it's only petty theft, I see.
Right, and I represent him on that one, right?
All right, so Mr. Radikoff, what say you with regard to the $1,000 bond?
No objection, Judge.
Okay,
Thank you.
you're welcome.
Good to see
Have a
you.
good day. You
Okay.
too. He'll be in court on Monday. Mr. Radikoff, don't forget Monday, 8:30. On the violation of the, didn't it say that on the front? FA, Judge Michael Lynch, 8:30 Monday morning. No, and Judge, yeah,
I didn't know, thank you, Judge.
you're welcome.
Monday at 8:30. Philip, I'll see you Monday morning.
He left already.
Monday at 8:30, Monday at 8:30, that's the second, 12.
Gregory Lee Mitchell, please.
Mr. Mitchell's approaching.
All right, Mr. Mitchell, good morning, sir. You have petty theft, second degree, third subsequent offense, $750 bond. Court does find probable cause. Court's gonna order no return to the target at 3200 North Federal Highway in Fort Lauderdale, sir.
This defendant is being supervised.
Hold on one moment. If you return there, ma'am, sir, you will be arrested. Do you understand?
Yes, ma'am.
All right, what say you, Ms. Patrice? I'm sorry.
This defendant is being supervised by pretrial service in case number 187925 CF10A for a felony petty theft. He was placed on pretrial supervision on October 24th by this court, at which time you told him not to return to Walmart based on this court
So
finding
now
of
he's at
probable cause.
Target.
The act of his pretrial status was revoked at this.
Okay, so what say you, defense?
Judge, as far as his financial situation, it hasn't improved. He's still on disability and unfortunately he's homeless. At this time, Judge, there's really no added information I can give to the court at this time.
All right, so court's gonna revoke his pretrial. I'll tell you what, I'll do a $2,500 bond on case number 187925 CF10A. And on this case, I'll leave his bond at $750, no return to the target. Thank you. Kedrick, sorry, Fabian Canino. Okay, Mr. Canino, you have grand theft auto, $1,000 bond. Count 2 is criminal mischief, between $200 and $1,000. First offense, $100 bond, resisting an officer obstructing without violence, $100 bond. 4, 5 are probation or community control violations. You're going to be held no bond. Count 6 is driving while license is suspended, habitual, $750 bond. Count 7 is a civil traffic infraction, disobey or stop or yield sign. Going before your division judge, Judge Barbara McCarthy, or is that Elizabeth Shear? Let me see. Judge Barbara McCarthy on Monday at 8:30 a.m. Court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials MAR. Anything else, State?
No, Judge.
Say, nothing? What's his priors?
He has a 2010 no valid DL, 2014 DWLS, 2015 trespass on public school grounds, 2015 grand theft, 2015 possession of PVP, 2018 grand theft, and 2018 possession of counterfeit bills.
Okay, what say you, defense?
Judge, considering he has a no bond hold on the VOP, I ask the court just to consider on the misdemeanors $1 bond.
All right, so I'll leave all the bonds in place except for 2 and 3. I'll set them at $1 each. No victim contact, direct or indirect, with the alleged victim with the initials MAR. Thank you, sir. Good luck to you. Matthew Walker.
His case was reset for the afternoon, is what I'm being judged.
I think they might have brought him back. I mentioned, Mr. Reedy, Your Honor, the state's going to request that this matter get moved to this afternoon. Detective Alonzo from the Hollywood PD is going to be present at that time.
All right, where's Mr. Walker?
We were told that early this morning, first thing.
Okay, I just was gonna tell him, no problem.
Okay.
Thank you. Christian Fernandez.
Mr.
Fernandez, good morning, sir. You have a grand theft auto $1,000 bond. Court finds probable cause. Court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials CEM. What say you, defense?
Judge, it's me, Mr. Fernandez, he gave me the friend that's gonna post his bond, so nothing to add from the defense.
The defendant is currently being supervised by pretrial services in case number 17-14267 CF10A, one count of burglary of an unoccupied conveyance. He was placed on pretrial supervision on April 6th with an electronic monitor. Based on this court's finding of probable cause, we're gonna ask that his pretrial status be revoked at this time.
All right, give it to me. Anything further from anyone?
No, Judge.
Okay, in case number 17-14267 CF10A, court is gonna revoke his pretrial and the court is gonna issue a no bond hold. This case will leave at the $1,000 bond, no victim contact. Thank you, sir. Good luck to you. State, your mic is on. Okay, that's yours. And that's over there. Thank you. Marlon Giles, please.
Mr. Giles, come on up, please.
Good morning, Mr. Giles. You have possession of cannabis, 20 grams or less, no bond required. You have trespassing, unoccupied structure or conveyance, no bond required. Count 3 is driving on a permanent revoked driver's license, $1,000 bond, Madam Clerk, do you have a driving record for Marlene Giles, please? 4, 5, and 6 are no bond holds. Those are KPS felonies. You're going before your division judge, Judge Ernest Calra, on Monday at 8:30 a.m. The court does find probable cause. Anything further, State?
The PC. No, Judge.
Okay, $1,000 bond, thank you.
Still looking for the driving record.
That's all right.
Yes, no bond holds. Would the court consider a $99 bond on
You
count
have
3?
this thing.
Yeah, because I took it out. There's nothing to do on it.
Can I see that back, please? You don't have his driving record?
I'm looking for it now. I don't think he has the driving record. I'm just checking.
Do you know why his driver's license revoked? Is it anything alcohol or related or drug related?
Check it right now.
Thank you.
For asking, actually. It's not a permanent revocation. I have no objection to the court finding probable cause for just misdemeanor DWLS. It was revoked in June of last year on an 893 suspension. It looks like he's eligible for, to reinstate on that if and when he chooses. It's suspended for other issues.
All right, I'll do a $1 bond. Thank you, sir. Good luck to you. And I found
Mr.
PC.
Giles is asking if you would consider an R1.
Fine, if he wants an ROR, that's fine. He has a no bond hold.
I know,
So,
that's what I said.
PC on count 3, per state and defense, or misdemeanor DWLS only. Thank you. Michael Hannigan, please.
Sir Hannigan, come on up, please.
Okay, Mr. Hannigan, good morning, sir. You have possession of heroin, $1,000 bond. Court does find probable cause. What say you, defense?
Judge, I believe he has a relatively clean record. I'm gonna ask the state if they can confirm if they wouldn't object to an R1 on his behalf.
State, does he have a prior history?
Judge.
The state's okay with an RR, Judge.
Okay, per state and defense, ROR.
Thank you. Thank you, Your Honor.
You're welcome. Michael Reed.
Mr. Reed is here present at main, Judge. Come on, Mr. Reed. And he, I believe advises he's proceeding pro se, Judge.
Okay. Okay, Mr. Reed, good morning, sir. How are you?
Good morning, how are you?
Fine, thanks. You understand, Mr. Reed, that if you can't afford an attorney or you can't get an attorney for today, you could fill out an application for the public defender and you'd have to pay a $50 fee. Obviously, you wouldn't have to pay that today. So you're giving up your right to have the public defender represent you, and you want to represent yourself, sir, or do you have a private attorney?
I do plan on it, I plan on getting one.
All right, so do you want an attorney to represent you today, the public defender's office? And you just pay them $50 whenever you can?
No.
Okay, so waive an attorney. All right, sir, let me tell you what you have. You have possession with intent to sell, manufacture, or deliver cannabis, $1,000 bond, possession of cannabis over 20 grams, $1,000 bond, resisting an officer, obstructing without violence, $100 bond, driving while license is suspended, $100 bond. You do have a civil traffic infraction, disobey a stop sign or four-way. It's actually not for magistrate. The court does find probable cause. Can you afford the $2,200 bond?
Yes.
You can? Who's gonna pay your bond?
My brother,
Have you spoken to your brother?
not as yet.
All right, so After court, they'll let you use the phone. Thank you, sir. Good luck to you.
Thank you.
Junior Robert Francois.
He bonded, Judge, he bonded.
Okay, court finds probable cause. Dervin Johnson, please.
Mr. Johnson is here present. Come on up, sir.
Good morning, Mr. Johnson. You have possessed counterfeit credit cards, 2 or more. Counts 1, 2, 3, and 4, $1,000 bond each. Count 5 is driving while license is suspended without knowledge. That's just an infraction. It's not even for magistrate court. No bond is required. The court does find probable cause. What say you, defense?
Judge, Mr. Johnson gave me the phone number of both his sister and his girlfriend. I intend on calling them after court to post his monetary bond.
Any no return or no contact, state?
One moment, Judge. Here, you can look up. What's the case number?
You said his brother's gonna post bond, probably?
His sister and his girlfriend.
Okay, and after this, we're gonna have William Sixto.
Not at this time.
State?
Not at this time, Judge, for Mr. Johnson.
All right, thank you, Mr. Johnson. Good luck to you. Okay, William Sixto, step up, please.
Mr. Sixto has family here, Your Honor, on his behalf.
Okay. Good morning. Can you state your first and last name, speak into the microphone, and tell me your relationship to Mr. Sixto? Can you speak into the microphone?
I'm Relis Baez' mother.
Spell your last name.
Baez, B-A-E-Z.
Thank you, and your name?
Jessica Sixto, sister.
Okay, and it's Sixto, obviously? All right, thank you very much. All right, Mr. Sixto, you have carrying concealed firearm, $1,000 bond. You do have possession of a weapon or an ammo by a convicted Florida felon. We need to talk about bond. Count 3 is possession with intent to sell, manufacture, or deliver cannabis, $1,000 bond. 4 is possession of a weapon or an ammo by a convicted Florida felon. We need to talk about bond. Count 5 is distribute or deliver Schedule 2, 3, or 4 barbiturate, $1,000 bond. Count 6 is drug paraphernalia, possess and/or use, $1,000 bond. Court does find probable cause. What say you, state, on counts 2 and 4 and any other special conditions? State here, defense here.
This one.
I would do 5,000 because I'm sure what's the You don't have to say this card specifically, but
Judge, for count 2, the state would be asking for 5,000, and on count 4 for 2,500. And for the record, he does have a violent prior when he was a juvenile from 2016.
What is that?
First-degree felony.
robbery with a weapon, Judge.
Okay. All right, what say you, defense?
Judge, in speaking to Mr. Sixto, he's 18 years old, been residing in our community his whole entire life. He was born in Pembroke Pines. Right now, he's actively looking for employment. Right now, he just finished, I believe, paying some sort of an administrative fee in order to try and obtain his GED, which he wants to go ahead and pursue. Hopefully, that opens up more job opportunities for Mr. Sixto. He lives in Pembroke Pines with his mother. I believe they recently moved into that apartment approximately 2 months ago. His mother is a caretaker. And right now, I believe their monthly rent is somewhere in the neighborhood of about $1,400. So Mr. Sixto is exclusively going to be relying on his mother to help post his monetary bond. My understanding, I believe, in the case that the state was referring to, he was placed, I believe, on probation, and ultimately probation was terminated, Judge. The judge, he believes that his mom, using the services of a bondsman, may be able to afford, if the court were to impose $1,000 bond on count 2 and $1,000 bond on count 4. So that is what the defense is asking for at this time, Judge.
Okay. All right, sir, no possession of any firearms, ammunition, or weapons. I am gonna do a GPS level 2. On count 1, $1,000. On count 2, $2,500. Count 3, court will do an ROR. Count 4, the court will do a $2,500 bond. Count 5, I'll keep the 1,000 in place. Count 6, court will do an ROR. GPS level 2, no possession of any firearms, ammunition, or weapons. Your bonds need to be posted first, sir, okay? And I'm sorry, I take that back. Is there anything further you'd like to state? You sure? All right. All right, so his bond has to be posted first, okay? 10% of the bond. So you just have to look for a bondsman, all right? Good luck to you. Thank you. Sean Otley.
Mr. Audie is approaching here at Maine.
Okay, Mr. Oddie, you have grand theft auto between $300 and $5,000. $1,000 bond, the court does find probable cause. Court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials KT. And court's gonna order no return to the Coles located at 12200 Miramar Parkway in Miramar, Florida. If you go back there, you'll be arrested. Do you understand?
Yes, ma'am.
Thank you. What say you, Mr. Romero?
Judge, I'm going to be asking for an ROR, and I'll see if the state has an objection with that.
What's his prior history?
Your Honor, it looks like he has a pending charge from last year in Quantico with the U.S. Army.
What's that for?
It's drug-related. Your Honor, we don't have an objection to non-monetary release. We would ask for pretrial supervision.
Can he afford a bond? Because I think he'd rather pay the $1,000 bond, pay a bondsman $100, rather than being on pretrial.
And Judge, then we'll ask for the $1,000 bond.
All right, $1,000. Thank you, sir. Good luck to you. Jessica Brockhart.
Joshua Brockhart, medical reset.
All right, so now. So we found PC in absentia. He's to be brought back to first appearance court for bond and conditions.
I believe that to be correct, Your Honor, yes.
Elias Velez.
Medical reset.
Okay, same thing. We found probable cause yesterday in absentia. Aaron McFadden.
Medical reset.
Same thing. We found probable cause in absentia yesterday. Where is he? Main jail? Okay,
Maine.
thank you. Javon Green.
Medical reset.
All right, so this one we need to have a finding. He was arrested on, says 10/22.
Your Honor, if I may.
Sure,
We're here because one of the charges is a change of charge.
okay.
And when the state filed information, we added 2 charges as well that he needs to have a first appearance on.
All right, so we need to find probable cause in absentia. Any objection?
Give me just 1 second, Judge. I wanted to pull up his paperwork. And I forget, because I had it yesterday, if there were bonds on the other counts.
No, they're
think
all HGs.
Well, Brian, are you talking about the accounts that are not before the court?
Yes.
I think he has a no bond.
Let me, just give me 1 second, Your Honor, and let me
Think-
just
Take your
check
time.
that.
Your Honor, Brian, he's got a bunch of no bond violation of pretrial holds.
All right, we don't have an argument on probable cause then.
All right, so PC in absentia. He has a no bond hold.
Yes, ma'am.
What count? You know?
6 through 16.
Okay. All right, so PC in absentia, defendant brought to first appearance magistrate court for bond and release conditions.
If I have this guy's case. It's not the bond,
And then the next one is Michael Dyer.
Your Honor, this was put on the morning docket by mistake. If you recall, you found no PC yesterday afternoon. We reset it. You asked if I wished to have it on the PM docket. I said yes, and somehow it got put on the AM docket.
So 24 hours to perfect?
Yes, ma'am.
All right, so
spoke with-
reset for this afternoon?
Your Honor, and in good faith, I spoke with the officer yesterday. I haven't gotten the report back yet, but I did speak to him, and he said he would be preparing me when. That's the only reason I'm asking to have it reset. If I hadn't spoken to him, I would
All
just
right, well,
go
we just
forward
reset
now.
it for 1 PM, no big deal.
Thank you.
It's Friday, there's a lot of cases on the docket. All right, thank you. So we'll be, oh wait,
We still
Jim
have Miss
Lewis.
Marius, Your Honor. Mr. Marius, I'm sorry.
What's Jim
Uh,
Lewis's
Roth.
number? I saw him last night at an event.
It's 954
Yep,
523
okay.
7949. Their office was gonna call me back. They may have when I was away from my desk, I don't know.
Yes, hi, this is Judge Malika. You're on speakerphone. You're being recorded. I'm calling from Broward County Magistrate Court. Looking for Attorney Jim Lewis. I have a gentleman in front of me who was arrested yesterday. His name is Mackinson Marius, Mereus. And he's telling me Mr. Lewis represents him. Is he available or an associate? Do you have a cell number that I can call him?
954
Okay,
907
okay.
2788.
All right, thank you.
Okay, thank you.
Bye-bye. Yes, hi, is this Jim Lewis?
It is.
Hi, it's Judge Malika. You're on speakerphone. You're being recorded in magistrate court. We have a Mackinson Marius in front of us. Do you want to magistrate him on the phone, reset to 1 o'clock? What would you like to do?
Sorry, what is his name, please?
Mackinson Marius, Mereus.
It's not somebody I'm familiar with.
Have you hired Mr. Lewis's firm, sir?
My fiance said she got in contact with him last night. I don't know if she retained him and paid him, but that's out from my knowledge. And I had him previously before on other cases.
Yeah.
All right, so Mr. Lewis, you want us to go ahead with the PD, or do you want to just do this today? It's a
We
grand.
can do it now on the phone, if that's
Okay,
okay, Judge.
that's fine. All right, so, sir, you have a grand theft auto, $1,000 bond, possession of MDMA, ecstasy, $1,000 bond, resisting an officer, obstructing without violence, $100 bond, driving while license is suspended, first offense, $100 bond, total bond is $2,200. State, what's his priors? Just give me the ones of sum and substance.
Yes, Judge. He has a pending case now, burglary structure unoccupied, case number 180044981 CF10A. And he has a prior burg dwelling from 2012 and another burg dwelling grand theft resisting without violence from 2012.
All right, what say you, Mr. Lewis?
Judge, I would ask that you don't revoke any of those bonds at this time. I don't believe I represent him on the 18 case, but.
All right, I'll let the state take it before his division judge. So he has $2,200 bonds. Do you want to ask your client any questions?
No, Judge, so I'll come and see him in the jail, thank you.
All right, so this is what I'll do. On count 1 and 2, $1,000 each, and 3 and 4, Mr. Lewis, ROR. Thank you. So
Thank you, Judge.
2,000
Thank you.
total, okay? You're welcome. Have a good day. All right, so court's in recess to 1 o'clock.